So a judge has absolutely wrecked AH as far as suing her own team in the courtroom is concerned, telling her in no uncertain terms that she is losing right now, and this is big time. Now, AH has a lot on the line. We are talking about 7 figures here. And beyond the money, she actually tries to blame this portion of her team for what happened in Virginia. That's right. Everything you saw play out, that wasn't her fault. That wasn't her defense's fault. No, it was because of this insurance company, because they prejudiced her and her defense. Now, a judge obliterates this argument, wrecking it in big time. You and I, we are going to talk about this today, too. Oh, man, fun times, huh? Fun times indeed. All right, so hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. So a judge has absolutely dismantled and wrecked AH's argument for going after her own team. They've said, as far as the preliminary findings here, I don't think you have any case whatsoever. This is absolutely absurd. And to truly understand what the judge is saying here, you have to understand what's going on and what AH is claiming. So in the aftermath of Virginia, you have the people that paid for AH's side of the trial going after one another, with one insurance company flatly telling the other and AH they don't have to pay for anything here. Why? Because AH has unclean hands. And AH answers back by saying, I want to sue you in return. I want a jury trial for this as well. And of course, the insurance company says, you don't have an argument for this. Let's get a judge to decide whether or not you get to go forward with what we consider a very weak argument. So after hearing both sides of the argument on AH's counterclaim, a judge decides that they're going to sound off on this. They give a tentative ruling. This ruling, by the way, it comes right before you have a hearing on this. The hearing, it comes up March the 13th, 2023, and the judge's decision, oh man, it wrecks every one of AH's points here. Now, the judge breaks all of this down really well, too, saying that AH's counterclaim, really, it has 2 claims in it. One claim is for breach of contract, and one is for tortious breach of implied covenant of good faith and fair dealing. See, a lot of people don't realize that AH knew that op-ed was going to get her sued. She didn't want to pay out a dime on the litigation, even knowing that it was coming, so she took out multiple insurance policies. This one sold to her by the insurer New York Marine for the period July 18th, 2018 to July 18, 2019. And she says, despite telling them in a timely fashion this was coming up, asking them to defend her, and them promising to do so, they actually did not provide the full and capable defense that she asserts that she was entitled to, failed to pay attorney's fees and costs that she believes they was obligated to pay for her defense, and acted in other ways that she contends prejudiced her and her defense. Again, it's their fault what happened. It's not her fault. It's not what we saw that happened. It's their fault, and she wants them to pay. Now, my favorite part of AH's argument is where she essentially replaces the lawyers that the insurance company here is paying for. Why? Because the insurance company, according to her, they have a reservation of rights, meaning they say that they don't have to pay for everything if AH acts intentionally or acted with actual malice. She says, well, that created a conflict of interest. That gives me the right to independent counsel, with the insurance company being obligated to pay for the fees and costs of this independent counsel. Now, of course, the insurance company said, nah, we're not paying for the lawyers that you want to bring on. We're paying for the lawyers that we think are the best here. And the judge sounds off on this, wrecking AH's argument entirely. Listen to this here. quote, duty to provide independent counsel. It appears to the court that AH's breach of contract, failure to defend, failure to cover expenses, counterclaim rests entirely on the success of her theory that the insurance company was required to provide her with independent counsel and could not fulfill its defense duties simply by appointing Cameron McElvoy's firm. Now, this is important too. Why? Because that firm wasn't initially picked out by the insurance company. Quote, the firm that AH herself had already retained before tendering her defense to New York Marine. They go on. Now, the judge says that this appears to be the only reason that she's saying that the insurance company had breached its contract. If this isn't what they mean, they better make that very, very clear too in their oral arguments presented March 13th, 2023. Why? Because the court has already determined on this. I mean, listen to this. This is amazing here. Quote, this court has already decided that issue, albeit in a lawsuit to which AH was not a party. This court has already determined, as part of the litigation between the two insurers, that would be Insurer A and Insurer B that I was talking about at the beginning, that because the JD lawsuit was proceeding in Virginia and because Insurer B provided AH with a Virginian lawyer, there can't be a conflict of interest at all. In reaching that conclusion, the court reasoned that choice conflict of law questions, they did not matter because these facts and the laws governing an insured Virginia's lawyer's loyalty remain true no matter what a choice of law analysis decided with regard to which law to apply to the independent counsel obligation. The judge continues by saying, those 5 cases that you brought up, saying these, they prove your point. Yeah. Only one of these really truly applies, and that case, even when presented, doesn't persuade us that what we said as far as our decision was the wrong one. Sorry about your luck. Now, the judge notes that beyond this argument of independent counsel, nothing else remains in the counterclaim. Outside of the issue of her alleged entitlement to appointment of independent counsel, AH offers no argument bearing upon any alleged breach of policy by the insurance company. She offers nothing whatsoever, no ambiguous portions, nothing that she can fight. So everything rests on something they have already decided. Accordingly, the judge concludes, she's going to end up losing this thing. She's not going to be able to take the insurer to task for this. The court will dismiss AH's breach of contract counterclaim, likely without leave to amend. The court will dismiss AH's implied covenant counterclaim with the leave to amend. And as far as the insurance companies want for more definitive statements, that doesn't need to happen at all. Why? Because all of that is moot. Again, Judge wrecks this stuff. It's amazing. She gets loss after loss after loss. You have to wonder what she thinks about going down this road at all. But anyway, let me know what you think about this. And as always, I appreciate the heck out of you. You make this stuff work. Thank you. Can't say that enough. Want to help out the channel, by the way? Links are in the description. Check those out. You being here, though, that matters. Share this. Appreciate you. Gonna end here. See you soon.